quick live stream. Um, Shout out to I Don't Belong Here, and along with her, I still want justice for Officer John O'Keefe. With that being said, let's get into this clip.
But
Um,
with systems, you see the exact same phenomenon. And that is precisely what we have here with Norfolk County and all of its law enforcement agents. You have a system that has slowly degenerated into a closed system where it does not allow outside information to infiltrate. And so, what do we have? We have all of these folks recycling the same garbage and getting used to the same types of infractions, not turning over all of the discovery, being late or sloppy with search warrants. And this is the kicker. What you get from all of these folks, whether it's Judge Canoni, that after all of the garbage that the Karen Reed defense team endures with this woman, she is awarded mid-second trial with an award, with the Person of the Year award.
how?
And by her peers,
How?
she's held on a post. She's held up. She's given accolades. And again, this is a closed system. So what do? They reward their own. They reward, they perpetuate, they reinforce all of these closed ideas to outsiders. And that's the way they like it, and that's the way they want to keep it. And that is why this is an intolerable situation for these people. This is why, in part, they pursued Turtle Boy so extensively, so aggressively, why
For
they were
no
willing
damn
to sell
reason.
their soul to this crusty panties character, because she was giving them information they wanted to hear. Now, we've been talking about the blue wall, and in a way, this is that. It is a closed system to outsiders. They reward loyalty to each other, to that closed system, and any potential outside information, any potential corrections to the system are seen as something to defend against, are seen as a threat. Exactly the same way as if you have somebody who's falling further, let's say, into a substance use disorder, what happens? Your loved ones try to help you, try to say, hey, maybe you shouldn't be drinking so much, or hey, I noticed that you haven't been yourself lately, and what does the person do? Pushes that person away, shuts them out, wants no part of it. And then, of course, with substance use, what do you see? People slowly closing the door on anybody who doesn't reinforce their ability to use substances continually. And that is how mental health and dysfunctional systems operate. That is what we have here in Norfolk County, and that is what all of what you're going to see here is about. To be 100% clear, this is not an issue specific to Adam Lally, to Michael Proctor, or even to Judge Beverly Canoni. This is a systemic problem. This is a problem with the administrators of justice in Norfolk County much more broadly. And how do we know that? All of these people, none of them see anything wrong with their behavior. In fact, they're often rewarded for it. So you tell me, what is the incentive to go against the blue wall, which in this case encompasses everyone? Look at the judges. Because, see, you can't just look at Michael Morrissey, you gotta look at everybody. Because how are these operating like this when judges are the ones who are supposed to be enforcing the laws, ensuring that people who are being charged with crimes are getting their due process, are having their constitutional rights granted, accounted for, honored. So how many judges has Adam Lally sat in front of and said some version of...
Your Honor, as far as discovery goes, we're in a fairly good position. In regard to that, I believe that was turned over just prior at the last date, so there may be a couple of other additional items of discovery that I need to get and turn over, but otherwise, I think we're in a fairly good position. You say that to the court, sir?
We think we've got most of the discovery. I mean, let's be honest, the defense in Karen Reed's case still hasn't gotten all the discovery. Still all these videos that just disappeared and never reappeared. Didn't seem to be a problem for our so-called judge in this case, right? She didn't seem to have a problem with it. In fact, her problem was with the defense.
After, he's been overruled, his objections have been overruled about 1 million times in a row. I mean, he's just pissing off the jury if he keeps objecting because he knows what's going to happen, right?
There was a witness, I took Howie, this is still just shocking to me. There was a witness that I took on direct examination, it's direct. And it's an expert, and you allow the lead experts in every state in the union. You can have moments where you lead experts. Every question I asked was objected to by Hank Brennan, and 100% of his objections were sustained. I've never seen that in 30 years of practice. Literally, I think it was 49 objections.
Okay, so in one of his Q&A of the direct witness, he doesn't say who it is, but it's not hard to figure out.
Okay, sustained. Correct. Sustained. Is that 10%? That is 10%.
The sustained is stricken. Sustained. I'm going to see it side on for a second.
On January 29th. Okay.
So can you narrow that, Mr. Jackson?
Sure. I guess the whole line.
That I need
They
to
was
stop.
coming down on Jackson.
I'm not curbing you in any
They was
way.
coming down on Jackson, man.
People will be there much longer. You know why we gave an 8-second range? Objection.
So ask it differently.
Okay. Objection.
I'm going to allow it. Do you agree with that?
Objection.
I'm going to allow that.
No. Objection.
I'm going to allow it.
Do any of the text stream of entry to any of the data that you reviewed either yourself through
And Hanky sucks, man.
Dr. Welch's report?
Hank Brennan sucks, bro.
There was a collision on January 29th, 2022 at any time. Objection.
Ask it differently.
According to Alan Jackson, that was a 100% success rate in having one's objections sustained on the part of Hank Brennan. Now, why is that so important? Besides, for the obvious reason, because it was the very first defense witness. This was our so-called judge doing everything she could to send the message to Alan Jackson, I'm in charge here. And you better do things the way I need or want you to if you're going to be able to get a single word uttered out of your witnesses. So this was her way of setting the precedent for the entire defense case in chief. That's why that witness was so important.
Inside, prosecutor Adam Lally requested the defense team no longer speak to the media.
The hyperbole or the language that's been used on the steps of the courthouse in reference to the Commonwealth having its foot on the defendant's throat.
The defense lashing out at that.
How dare the prosecution try to prohibit defense counsel from doing our jobs? How dare they ask this court to take away our First Amendment right to free speech?
All this happened after defense attorneys had accused the judge of appearing biased against them.
They are.
She removed
And Bev was
her
biased.
from an internet
I don't care what
post
nobody
saying she
says.
knows potential prosecution witnesses, something she strongly denied.
But I want to make it very clear that I reject the notion that untrue and unsubstantiated rumors spread on the internet can force a judge to recuse herself from a case.
We need to be heard on this.
That's why we're here, Mr. Knight.
I'd like to start with the most outrageous and false assertion that the group made in its motion.
Can I just ask you, there's no jury here, can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay. Because I don't need, the hyperbole.
I need to make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its...
They need to investigate Bev too. Hank Brennan need to be investigated, and Bev need to be investigated.
Involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page
What?
21.
I have the Commonwealth's renewed motion for reciprocal discovery defendant's expert, Dr. Marie Russell.
That didn't make no sense. That don't make no sense. When they're supposed to be part of the case.
I'm on page 3.
It's not on page 4. My apologies. My name is right there on page 4. It says exactly what I just argued.
It's very clear to me now, with a little more distance from the trials, that the judge did not like how the defense began to use the media, aka Turtle Boy, to gain a following. She felt like the defense was putting on a show for the people outside of the courtroom. That the theatrics were all for us. And she didn't like that the big shot attorneys, right? The heavy hitters from California and New York were all of a sudden on her turn. So it was really important that she make sure they never forget whose turn they were on. And don't take my word for it.
She could not stand me on bullet 1. That's not how we do this in Massachusetts. And when Judge Cannoni said, we stand up in Massachusetts, Miss Little, I was like, we don't stand up when we address judges in California. It's not a disrespect thing, it's an efficiency thing.
Who the fuck are you? Like, she's from Norfolk County. Like,
Right.
This is her, she's been here her whole life. Who the fuck are you? You're not gonna come in here. She had to remind you, God damn it, this is her goddamn courtroom, and she's gonna remind you of it whenever she can.
It certainly seemed like the Judge Cannoni had an idea of what she thought should be presented to the jury and how she thought it should be presented to the jury. Instead of just being, calling the ball to strike, that's what she's there for. You don't want to allow abuses on either side to occur in your courtroom, but you allow the lawyers to try the cases. You allow the lawyers to direct examine the witnesses or cross-examine the witnesses. You allow the evidence to come in before the jury.
She was basically poking her chest out at him. It's basically what he's saying. She was basically using every chance she had to poke her chest out.
Because ultimately the jury is the trier of fact, not the judge. The most important folks in the room are the jurors. And it struck me in trial number 1. She did the same thing. It was just, in my view, abusive of the process.
If you could speak directly to Judge Cannoni, what would you say to her in criticism of what she did?
Well, be careful. I am an officer of the court in every jurisdiction in which I pro hoc, and I can imagine I may be back here in Massachusetts again. I doubt I'll be in front of Judge Cannoni. But my suggestion would be don't try to put your thumb on the scale. No judge should ever try to put your thumb on the scale. Let the evidence get before the trier of fact in a fair and, above all else, in an impartial way. I did not feel this was an impartial judge. I just didn't. And I don't think anybody who's watching
No.
would argue with that.
This afternoon, Judge third-party culprit defense. It's a change from the first trial, one of many in this high-profile case. Judge Beverly Canoni says with proper evidence, the defense can identify Brian Albert and Brian Higgins as third-party culprits, but not Colin Albert, as was the case in the first
Really?
trial.
It's just really ironic.
Why not Colin?
Colin Albert is the one who the judge decides to exclude.
Why not
saying
Colin?
that there wasn't enough evidence that he's in the house. Well, there's not enough evidence that he's in the house because there was no investigation done as to whether or not.
Reason I'm pausing this cause I'm gonna try to come back later on with a different take on this case right here from Ron Mango. I was gonna do it some other day, but I just might do it tonight while I'm thinking about it. Cause Ron Mango has a wonderful breakdown, and I wanna play that tonight if I can. If not, I'll play it tomorrow.
He was in the house, right? None whatsoever. So the only thing that we have to go on to determine whether he was in the house are the statements of the very people who the defense is accusing of killing John O'Keefe. Right? Think about how ridiculous this is. I mean, really think about this, okay? The judge who works for the Commonwealth, okay, and tries cases routinely with this group of DAs, is making the decision that the defense is not allowed to present evidence that Colin Albert could have been involved in the death of John O'Keefe, because the people who they are accusing of being involved in the death of John O'Keefe say he wasn't in the house. And I swear by this, I 100% firmly stand by the claim that Michael Morrissey handpicked Judge Beverly Canoni because he trusts her completely, because they grew up together, because they're from Quincy, Massachusetts, because their parents knew each other, because.
Some have, without any evidence, pointed to 18-year-old Colin Albert.
Please, quiet.
And this douchebag.
And oh yeah, that kid's parents, that kid, Colin Albert's parents, are the ones who helped Mr. Morrissey, the district attorney of this county, write this statement. For example, on August 25th, 2023, presumably at the request of Mr. Albert, his wife Julie, and others, you took the virtually unprecedented step of making and then widely disseminating to local and national broadcast and print media a formal statement defending your ongoing murder prosecution against Karen Reed. Among the reasons you made this ill-advised public statement was to A, implicitly criticize Mr. Carney, and B, vigorously vouch for the credibility of the Albert family and other witnesses against Ms. Reed. On information and belief, after acting at the specific request of Mr. Chris Albert and his wife, to Chief Rafferty, you allowed them, as prosecution witnesses, to edit the contents of your public statement while you were literally filming it.
And issued the homeowner and accused him of attacking John O'Keefe as he entered the home.
The phone never shows, O'Keefe never entered the home at all.
This could include reasons such as the device entered a building-covered area, the result of weather conditions, geography, poor connectivity, or interference, to name a few. So those are the reasons you gave, which could contribute to some low accuracy, correct?
Correct.
Then you go on in the next paragraph to say it is known that the device was not being used at this time. So that's another reason why, right, the accuracy could be a little bit on the lower side.
Correct.
Now, the next paragraph says, at 12:38:13, when the device begins recording higher, and that's relative to what it was recording before. It's not that it's high, but it's higher than what it was just moments before.
Correct.
The data centers on a location slightly closer to the house than the roadside. Although several records show the same center coordinate with differing accuracy radii. There are two white circles, the largest one, then. This, in fact, was a depiction that you included in your report on page 29, correct?
Correct.
The phone of John O'Keefe, according to this depiction, could be anywhere within the largest white circle, correct? Interesting and notable, you did not include that depiction in your timeline that you discussed with the jury yesterday, did you?
I did not know.
Notably, the larger white circle covers a substantial amount of the house at 34 Fairview, correct?
Testimony from witnesses tell us that 18-year-old Colin Elvin had left his uncle's home before John O'Keefe and Karen Reedy had arrived outside the residence. Colin Elvin, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative.
He was not at the house when John was there.
But why would it matter if he was inside and John O'Keefe was killed outside by Karen Reed? Why did he call Erin Beatty, a girl he wasn't dating, out of the blue at 12:33?
We have the district attorneys putting out a video statement to the media in August of 2023 defending the very people that the defense is accusing of murdering John O'Keefe.
Weird.
There was no fight inside that home.
You know, so one of the things that comes up a lot, I get a lot of emails and comments, and I try to read all of them. Even if you don't get a response back from me, that doesn't mean I don't see what you're saying. I absolutely do. And a lot of people have questions. Could John have just slipped and fallen? Is it possible that nobody's to blame, that he was just drunk and, you know, he stumbled out of the house and he fell and he hit his head? To be totally honest, I have had those kinds of thoughts myself, of course. It was my independent full investigation of the injuries of John O'Keefe before the second trial that pretty much conclusively rules out that option. And I will tell you that there are two definitive pieces of evidence that take it off the table completely. One is the vomit on his shirt, and two are the bruises on his hands. And it's interesting that there's really, as far as I can tell, or that I have found, one reference, only one reference, to bruises on the back of John O'Keefe's hands. And it comes, I believe, from Yuri Buchanan on direct examination with Hank Brennan. But both of his hands were bruised. I want you just to take a look at John's hands. Here's something really interesting. The only places that we see bruising, not on the torso where you would expect to see bruises from somebody who was hit by a vehicle, Not even on the arm where the Commonwealth is saying John was hit, directly hit by the taillight. No, the only place where we see bruises are on his hands. Isn't that interesting? And if you look at this hand here, I guess that's his left hand. It's like it's blowing up, like it's swelling up. Why would it do that? I wonder what would cause someone's hand to swell up like that. I literally superimposed this guy on top of her image and just copied the marks. So, think about where these injuries are. We have a tiny scratch under the left eye and on top of, or just on top of, the left eyebrow. We also have injuries to the left frontal lobe, okay? That's this down here, left frontal lobe, and the left frontal pole, okay? So now, take your hand, put it into a fist, and put that right up, match it up with where John's scratches were. And what do we have right at those spots? Those are knuckles, knuckle marks, right? This is my left, you're looking at me on the right, but I get punched here, and where does the damage go? It starts at the left frontal pole, goes into the left frontal lobe, and stops at the left lateral fissure, right there. Okay, so, 2 punches, that's all I would have had to have taken. One, the left side, and then, she doesn't stop there, Dr. Stonebridge. She goes on to say that he also has bruising on the right temporal lobe, and that matches with these marks right here. So again, now we have, take your fist and just line it up with the cuts on the side of his eye, side of his eyebrow, on the right side, and then also the right temporal lobe. You tell me that he wasn't punched in the face like 1, 2, right? I mean, it lines up perfectly. You do it yourself. Now I have
Lines up to him being in a fight.
But if they were bigger,
Exactly.
if someone has a bigger hand, that one punch could have essentially, this mark here could have been from the pinky, and it could have encompassed, this mark here could have been from the pinky finger. One punch could have encompassed this whole area here that Dr. Stonebridge is talking about. Just one punch. This doesn't seem like rocket science to me. Now, maybe I'm delusional, maybe I'm crazy, but if you look at the cuts on this man's face and you listen to what this woman, Dr. Stonebridge, says, these marks are almost definitely, they're not from a car. This is from someone being punched in the face.
As a matter of fact, both you and Sergeant Buchanan believe that he had suffered the injuries as a result of a physical altercation based on information you received from the paramedics initially, correct?
Initially, we didn't know what we had. We knew there was some significant injuries to Mr. O'Keefe. There was still figuring out how those injuries occurred.
Well, you just testified. Initially, we didn't know what we had.
Right.
But 16 hours after the fact, you wrote the following sentence. That's what I initially thought after talking to Canton paramedics. Correct?
Correct.
So initially, you did think you knew what you had. A physical altercation leading to the death. Correct?
Correct.
You were aware, initially, that John O'Keefe had suffered a 2-inch laceration to the back of his head, correct?
Yes.
That resulted in a skull fracture, correct?
Correct.
He had a laceration over his right eye, small laceration just under the eyebrow, correct?
Yes.
Had a laceration on his nose, is that right?
Correct.
He had patterned scratches on his right arm, abrasion scratches, correct?
Yes.
And he had no injuries below the neck.
Not that I observed, sir.
Not a single broken bone, correct?
Not that I was aware of.
Not a single fracture, correct?
Not that I was aware of.
Not a single bruise below the neck, right?
Not that I observed.
Looks a lot like a physical altercation, doesn't it?
Objection.
Sustained.
Bird writes, Bear, let's focus, correct?
Yes.
Who's Bear?
That's another nickname I have.
0095 writes, what does she waffleman mean? And then Bird writes, what's the story, correct?
Correct.
And you wrote, she hit him with her car. Is that right?
Yes.
Have you ever seen, in your experience, have you ever seen a pedestrian who was hit by a 6,000-pound car with no bruises? Ever?
The pedestrian strikes I've seen have been at high speeds, 60 plus.
A person on the shit, right?
60 plus miles per hour. So I can't recall right now off the top of my head as far as injuries in the past pedestrian strikes I've attended.
This is me reminding you to like this video, comment, subscribe, like this video.
What she said.
Jackson showed a picture
Like,
of
comment,
taken less
share,
than a month
subscribe.
after John O'Keefe's death, with bruises on his knuckles. The defense has said O'Keefe was killed during a fight.
About what time of day was it? That's you in the middle?
Correct.
Why didn't? Yeah, the prosecution didn't even want this dude interviewed.
An event, some sort of issue or cause.
Colin Albert.
I want you to take a look at your right hand. Can you see from there?
And I'm gonna quit pausing it cause I'm gonna be a little bit pressed for time. But notice that the defense wanted Colin Albert interviewed, but the defense didn't. This lady here talks about it, and that's another lady by the name of Ryan Mango who actually did an extensive breakdown on how the Commonwealth wanted Colin Albert excluded from the case entirely, and I guarantee y'all I will do that this week. I don't know if it's gonna be tonight or if it's gonna be later on this week, but the stuff with the John O'Keefe and the Albert family, I do extensively want to get to that this week.
Your right hand?
Yes,
What do you notice about your right hand?
it's cut up.
Your knuckles are injured, correct?
Correct.
Albert said he got hurt when he slipped on a driveway.
I was at a party, a house party my senior year, and I remember it being icy out, and it was kind of like a steep hill of a driveway, and I was walking up the driveway, and I slipped down the driveway, and I tried to catch myself, but I had something in my left hand, so I tried to brace myself with my right hand, and I ended up sliding a little bit down the driveway.
What do you have in your left hand?
If I remember, it was either my phone or a beverage.
So, according to you, you fell on ice and injured your knuckles, as we just saw in that photograph, right across the top of your knuckles.
Correct.
So you fell onto what, pavement, asphalt,
Yes.
and you braced yourself when you fell your entire body weight by putting your right hand down in a fist, and you injured your right fist, just the top of the knuckles on your right fist when you fell down.
Correct.
I call Cap.
Objection, Your Honor.
Sustained. You'll notice there that somebody whispers to Adam Lally, or somebody has to whisper to Adam Lally to object there. Now, I'm going to go ahead and assume, because we don't have video of it, that it's Mr. Laughlin. However, I did catch the
I
judge.
would for
Judge,
getting glasses.
Our so-called
Hold on.
Judge Beverly Canoni, aka Michael Morrissey's Person of the Year in Norfolk County, I did catch her helping Hank Brennan to object during the second trial.
Which
So
she
was
did.
it surprised if it was her whispering to Ally?
Hold on, y'all.
Absolutely not. However, in this case, I don't think it was.
Do you remember anything about this case?
Colin Elvin didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Elvin. These people were not caught in a conspiracy and certainly did not commit murder or any crime that night.
What about the district attorney, Michael Forsey, who got 3,000 pages of evidence from the FBI, pretty much concluding that the client did not strike John O'Keefe?
For Michael Morrissey, I have a lot more to say than I have to say to Judge County. Michael Morrissey, the overall arching comment is do better. Do better, sir. You are in the job of seeking justice. You're not in the job of weighing cases. And that's what it seemed like he was doing. Not seemed like, that's all he was doing. And that's what Hank Brennan was doing. And that's what Lauren McLaughlin was doing, who was writing all the papers, the abusive process, trying to keep all of our witnesses out of the courtroom. Lauren McLaughlin, hundreds and hundreds of hours filing motions, trying to keep our witnesses away from the jurors. Ultimately, we were able to overcome it. But it was not easy, Howie. I gotta tell you, this is one of the most challenging, this is the most challenging case I've ever tried in my life. And we didn't win because of the process. We won despite the process that put in place in that other courtroom. It was a travesty, in my view. An absolute travesty.
Yeah.
What was the worst thing that they kept out? The fat dials, the FBI, the solicitation of a bribe?
You just hit the nail right on the head. The FBI. How can you possibly defraud a jury by saying, okay, you're not allowed to
Defraud a jury. This is Carol Reed porn to me. FKR porn. This is amazing. This is everything I want to hear, and it's coming out of Alan Jackson's mouth. He is just letting loose. It's awesome.
The fact that Barker was hired by an independent agency, the FBI and the Department of Justice, DOJ, and at the same time allow the prosecution to sit up and cross-examine the very witnesses that were hired by the FBI and call them your employers. Are you kidding? That was not a mistake. Hank Brennan did that absolutely on purpose, and he did it because he knew he was going to get a very favorable call by the judge. We objected over and over. We opened the door. This was perpetrating a fraud on the jury. This was not their employer. And nowhere close to being their employer. Their employer is our guy.
Yeah.
When we went to sidebar, look, you can't listen to the FBI. And the Commonwealth was still able to perpetrate this just abject fraud on the jury. Now, thank God the juries were smart enough that they did not allow that to affect their ultimate judgment. But that's the kind of abuse that should not ever happen in the courtroom.
They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in a case. She's always letting on the student court and jury case down here.
My daggone Wi-Fi. Hopefully it'll come back in a minute. If not, I'll just end the live stream and come back some other day. Okay, good. It's back green. Give it a second, y'all. Give it a second. Come on. Come on. Rewind this a little bit.
And the Commonwealth
There we go.
was still able to perpetrate this just abject fraud on the jury. Now, thank God the jurors were smart enough that they did not allow that to affect their ultimate judgment. But that's the kind of abuse that should not ever happen in the courtroom.
They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in a case. She's always letting on the student court and jury case down here. She's the truth, the whole truth, and nothing but the truth. So
I did. You indicated on cross-examination you've never been in a fight.
No.
You indicated that there's no violence. No violence.
No.
You stand by that testimony?
Correct.
Your opinion was, I will be on there.
That I would beat them up.
Did you say up, or did you say, I will
I said I will F you up.
No, you didn't say, I will F you up. What did you actually say?
That I would F them up.
You also said something about beating somebody's ass, right?
Correct.
What does that mean?
That I would beat them up.
So when you said, I will F you up and I will beat your ass, is that a friendly invitation?
No,
That was a threat, correct?
I don't know if I would call it a threat.
Yeah?
I'm not sure.
Someone walks up to you, I'm not gonna do it. Someone did, walked up to you and said, I will beat your ass. Right?
If they walked up to me, yeah.
Were you threatening advantage boys, guys, whatever they are?
Yeah, kinda.
Threatening them with violence?
Kinda, yeah.
Yeah.
Now, yesterday, Colin Albert testified that he was at the house on the night
Okay, there we go.
but never saw John O'Keefe.
Why did his family try to silence the beatings?
Here we go.
Why did his mother offer Proctor? Thank you.
Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict.
Why they protecting this Albert family?
In this case, you were tasked with the responsibility of making sure that the investigation remained free of any conflicts of interest as part of your job, correct?
Correct.
Throughout the pendency of this investigation, in this case, you've denied having any conflict of interest in this case. Isn't that right?
Correct.
In fact, a couple of months ago, in February of 2024, you testified in a different proceeding. Is that right?
Yes.
And you testified under oath in that proceeding on February 1st that you did not know any members of the Albert family or McCabe family, correct?
Certain members of the Albert family I did not know. I know Chris and Julie and Colin. I don't know the McCabe's.
That wasn't my question. Did you testify, let's take them one at a time. Did you testify under oath, same oath you took here today, in a formal proceeding in February of 2024, that you did not know and did not have any relationship with members of the Albert and McCabe families? Did you?
I haven't had a chance to review those minutes. I've only had one opportunity to, and that was a couple months ago. So I would want to review those minutes in order to answer that accurately.
You can't remember how you testified, whether or not you knew or had relationships with the Alberts and McCabe's?
Objection.
Sustained.
If you'd review that and we'll talk about finish. Would that refresh your recollection about the question and answer that you have, a series of questions and answers that you had while you were testifying under oath in that other proceeding?
Yes, sir. Objection, may I reproach?
Yes.
Mayor? Yes. Thank you. You were asked the question, quote, did you communicate with First Assistant DA Veland that you did not know and had no relationship with the Albert and McCabe families? And you answered, quote, to the best of my recollection, the same conversation took place with everyone I talked to about this, because it's the same answer. It's the facts that I shared with everyone. Question, meaning you told First Assistant Veland that you didn't know, didn't have a relationship with
Objection, Your Honor.
members of the Albert and McCabe families. Answer, correct.
Yes, that's correct.
So your question is whether he said this?
Correct. Whether that's his testimony. Do you recall that?
Yes.
And that's your testimony that you, in fact, told members of the DA's office that you did not know and did not have a relationship with the Alberts or McCabe's. Is that right?
I did not know the McCabe's. I don't know most of the Alberts, and I have little to no relationship with Chris and Julie. So that's what I meant by that answer.
Well, the question wasn't, did you know most of the Alberts? The question was, did you have a relationship with, or did you know the Alberts? And your answer was, no.
No, I don't have a relationship with the Alberts.
Or know them.
I don't know the McCabe's. I don't have a relationship with the Alberts.
So you do know the Alberts, correct?
I know some of them, Julie and Chris.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident.
You have a broader responsibility, not just to do a job, do the right goddamn thing. Do the right thing. Do the right thing. I did, when I was a prosecutor, every single time I did the right thing. People have asked me as a prosecutor, oh, do you ever lament the idea that, you might have convicted an innocent person? No, I didn't. Because I did the right thing. I knew what the evidence was. I knew exactly what I was doing before I ever walked into a courtroom. I never, ever had to lose a wink of sleep with the idea that I got it wrong. How could these folks, the Laura McLaughlins and the Adam Lalleys and the Hank Brennans, ever sleep at night thinking they got this right? If they're real legal analysts, not a single one think that she did this. Not a single one of them. If they're real legal analysts, they're looking at the same evidence I'm looking at. As a matter of fact, I suspect they're probably looking at more evidence than I saw, which is unconstitutional. But
Yeah, it sounds like it.
Yeah, I have no reason to believe that they didn't have additional evidence that I never got, that I never saw, that I was never able to analyze. But you're dealing with Buchanan, and you're dealing with Tully, and you're dealing with Proctor, and these folks who are bent. They're just bent. Every one of them are bent.
Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road.
All I cared about was timing. I cared about the timing at which the first taillight was found, which was well after Proctor had that car in his custody and had access to 34 Fairview. And number two, I cared about who actually recovered the pieces and who photographed them. And those were Tully.
In addition to having no opportunity to plant the evidence, as has been suggested,
Were there other people in the area outside the scene of the grid that you were going to search, other than you and members of your search team?
Lieutenant Tully are on the scene.
Was there anybody with Lieutenant Tully?
At one point, he had several other people with him, maybe I believe 5 throughout that search, maybe 5 different people, including him, were on scene.
Were those people part of state police?
At least 1, maybe 2. Unfortunately, I don't recognize all 2,500 members in our department, but there were probably about 5 total people on scene, sir.
Where was it first that you were heading to? I first went to the Camp Police Department to talk to Chief Berkowitz, and wait for the arrival of the CERT team, and then the 34 Fairview. And then the 34 Fairview.
now, Lieutenant Tully, was he on the scene when you arrived?
He was not.
And at some point, did you reach out to him?
Yes, I gave him a call. He stated he was just leaving. Canton PD would be on scene in about 5 minutes. That was probably around 5 o'clock.
When you first arrived at Fairview and you looked at the scene, did you have any personal knowledge where any person had been in that area?
No, I did not.
Did you learn generally that a man was found in that area?
Yes, I did. I made the final markings of the distance we wanted to search, but we were guided by Lieutenant Tully's information he was able to provide for me.
At some point, you respond to 34 Fairview, is that correct?
Yes.
And do you recall about what time it was that you arrived there? About 5:30 p.m. About 5:30 p.m.
Do you know what time it was that you actually began searching?
We moved my cruiser and Trooper Boussolet's cruiser at 5:20. We started gridding off where we wanted to search, but at 5:20, that's when we moved our cruisers, put the headlights on. He had instructed us that the death investigation involved a motor vehicle. He told us where the motor vehicle was believed to have been parked and wanted us to search from that area south towards the flagpole fire hydrant.
Did you wait until the entire team was there before you began?
No, we did not.
Did you wait until the entire team was there before you began?
No, we did not. Once all the members got on scene, we set up a line search, or what we call a grid search, which again would just be a slow, methodical search with all of us working in unison, moving through the area. Once all the members got on scene, yes, once I spoke to Lieutenant Tully, we wanted focusing on a specific area to search. After we found 1 or 2 of the pieces of the taillight, I asked him if he knew how big, how much damage was to the taillight, or if he had a photo that we could get of the taillight. He told us at that time the vehicle was being towed back to Canton PD, so he did not have a photo to show us. He said Sergeant Buchanan and Trooper Proctor were following the vehicle back to Canton PD. Because this was such a small search area, our members lined up almost shoulder to shoulder. Once we were on a line, we would slowly move forward
each member taking out snow, sifting, small layers, sifting it out at their own feet with a right flank along the curb in front of the house. That snow would eventually get moved out to the street where I was standing. I was the left flank on our line. I would then re-go through that snow, make sure we didn't miss any items or by accident carry an item that we were looking for over towards the middle of the street. Once I was satisfied there wasn't anything there, I would take that snow and throw it across the other side of the street.
And with respect to the search that was conducted by Lieutenant O'Hara and members of the search team, where was that in relation to either the roadway or the front lawn of 3450?
Well, as we were excavating this, or as they were excavating this snowbank in front of it, we realized that the snowbank protruded about 3 feet into the roadway. So as they were moving this first part of the snowbank, we're essentially shoveling the road. As we were excavating this, or as they were excavating this snowbank,
The items that you're photographing, were they moved in any way prior to you memorializing them on photographs?
yes, this piece in particular, the search team member, as he was removing the snow with the shovel, had picked up this piece of plastic with it. I asked him to place it back where he found it, where it approximately was, so I could memorialize it in place.
So it's picked up, you asked him to put it back where you found it, and he did so?
Yes.
Lally, of course, was the lead prosecutor in the first Karen Reed trial. He worked with the lead detective, Michael Proctor, who we know has since been fired. But today's hearing has been centered on him and another case he was investigating. Proctor, however, a no-show today. Lawyers for Miles King have asked the Commonwealth to produce all discovery evidence in the case, alleging the Commonwealth has not been forthcoming. King is accused in the 2021 killing of Marquis Simmons.
Let's assume that the return to be back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021.
Certainly, there ought to be some degree of sanction here, whether it's suppressing of evidence, excluding evidence, and I wouldn't be surprised if there ought to be professional sanctions against Lally. He is an officer of the court charged with the responsibility of disclosing evidence. And let's be clear, this evidence, these search warrants, were in his actual possession, custody, and control from the very beginning. If you watched this hearing last week, they talked about these search warrants to the grand jury. He knew they existed.
So, when do you realize that you never turned over the search warrant? When do you realize?
As far as the 2021?
When did you get the search warrant in your custody?
In my custody?
Yeah.
I would say probably I became aware of it a month ago.
Proctor is not the one with the Brady obligation. It's Lally. He's the attorney that is charged with responsibility. He's the one who should have known and hounded Proctor for evidence that he was required to get. There are so many things that he could have done. Why did he make representations that you saw in this hearing at prior court proceedings saying that I've essentially complied with all of my discovery obligations, knowing that he would turn over these search warrants?
2025?
Yes.
July of 2025, or June of 2025?
Yes.
Is the first time you became aware that you didn't turn over the search warrant?
Yes, if I had been aware earlier, then I would have turned over the search warrants.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then, when did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to 88 Hickman.
Well, let's talk about that. What date was the case transferred from you to 88 Hickman?
Okay, probably somewhere in October or November of 2024.
2024?
Yes.
And how does the case, let me say in general, how does the case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. Chaney and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. Did you have a conversation with her?
Yes.
And did you tell her, hey, this search warrant that I was never able to get from Cooper Proctor?
Again, if I had known or remembered that the search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
So at a real DA's office, they wouldn't tolerate this. They would get rid of them. They wouldn't let them handle these cases. And if there was a larger, more interested media out there, they would be asking Michael Morrissey these questions. Is he still handling murder cases? And if so, what are you going to do about this? And you saw this type of testimony and how there's no policy. There's obviously a culture of non-disclosure in that office. There's clearly negligent supervision going on in that office, even at the highest levels.
I didn't know that they weren't going to ask me more than what they asked me that.
Oh.
So, like I said, I recanted exactly what I did that day when I showed up at the residence, and I told them, the last thing I said was that, there was a crack, a piece was missing and it was not completely damaged. And, they talked about a picture, and I said, no, I wouldn't agree to a picture of a completely damaged taillight.
Yeah.
When I went on the stand, I didn't know exactly. I knew some of the stuff that they were going to ask me because, it was going back and forth when we prepped, but I didn't know that, after I said, it was a crack, there was a crack, a piece was missing, and not completely damaged. I didn't know that was going to be the end of it.
All right, whenever you're ready, Mr. Lally.
Good morning, sir.
Morning.
Could you please state your name and spell your last name, Jerry?
Nicholas Barrows, Barros.
And how are you employed, sir?
Town of Dayton.
And what, if any, role, or what do you do for the town of Dayton?
I'm a police sergeant for the police department. I believe it was around 2:30 in the afternoon. I received a phone call from the Norfolk District Attorney's Office with the troopers assigned there, and they had stated that they were going to come to Dayton to retrieve a vehicle that was involved in a homicide.
Did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon he intended to seize the vehicle?
I believe that the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they would come into that occurred in a homicide. And
can we have some legalese and some aware of a warrant that was executed on that vehicle on February 1st, 2022?
I am aware.
And you yourself were not present for that, is that correct?
I was not present for the execution, no, sir.
Trooper Proctor was, as far as you're aware, is that correct?
That's correct.
When you say it was a snowstorm, we couldn't get into the driveway. Can you expound upon that a little as far as explaining to the jury why it was that you couldn't get into the driveway?
There was about a foot of snow in the driveway.
And as far as that snow that you observed when you arrived there, was that snow, how did that snow appear as far as, had it appear as if it had been shoveled or snow blown or untouched, or how did it?
It was untouched.
Now, as you're going through the snow, and correct me if I'm wrong, but it's yourself, Proctor, and the sergeant from the state police, or if anyone else is going along with you.
I had a field training with me that day, and he was with me as well. And we went up to the residence.
If you recall, from where you're standing at the point of the garage, was what part of the vehicle was facing you? Was it the front of the vehicle, the back of the vehicle, the side of the vehicle?
I was looking at the left side of the vehicle.
And at some point, did you make any observations of the right rear part of that Lexus SUV?
I did.
What, if anything, did you observe about that area of the vehicle?
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked, and a piece was missing, but not completely damaged.
And then beyond the taillight area of that vehicle, what, if anything else, did you observe as far as damage to the rear passenger side area?
Like a dent on the rear quarter.
And as far as the dent on the rear quarter of the camera, was that above the taillight, below the taillight, or something?
Probably right in conjunction with the taillight in that same area.
they had said, there's a picture that, the taillight is completely damaged, and I had told them that's not what I saw. So fast forward to when I actually get onto the stand, and they asked me questions. And when I said, that a piece was missing and it was not completely damaged, they never went on to ask me more because they knew what I was going to say, and it didn't go for them.
Sergeant Barrows, is this the condition of the right rear taillight when you showed up at the Reese Reed household at around 3:15 in the afternoon on January 29th, 2022? Absolutely not.
And from the time that you made these observations of the vehicle, at any point did you go sort of physically up to the vehicle?
I walked up to the vehicle, correct.
And about how far away from the vehicle did you get?
5 to 10 feet away.
And as far as in this area of the right
Okay,
rear
I'm
passenger
back.
side of that tail, was there any snow or ice or anything around that area?
Yes, on the vehicle there was snow on the vehicle.
Words in your mouth was sort of caked on there? Is that
See
correct?
how much more I got.
I guess you could say caked on, correct.
Okay, I got a little bit
So
more.
you reached out to the highway superintendent to have someone come out and plow the front, correct?
Correct.
And
Come
do you know
on,
about how long it
Wi-Fi.
was between the time that you made that call and the time that the plow driver came
Come
out to
on.
clear?
Less than 10 minutes.
And the sort of
Give me
clearing of the
15 more
driveway
minutes.
process of that, about how long that took.
I'd say another 10 minutes or so.
And as far as the time that the troopers went into the house, at some point the troopers obviously came out of the house, correct?
Correct.
You know about how long it was that they were inside of the house?
More than 30 minutes, less than an hour.
Now, at any point in time, in the
Come on,
call,
Wi-Fi.
did you yourself or did you see anyone else
Come on.
touching or making any contact or manipulating or anything in that rear passenger side area, that either the taillight or the vent?
Oh, Lord Almighty. Come on, come back in. If it don't come back in a minute, I'm just gonna end it right here. Wait a minute, hold on. Okay, it's back. I just need to last me 10 more minutes. And after that, I'm done. Again, y'all, I apologize for the struggle streaming. Please like, share, subscribe. And I pray and hope that the weather is better where you at. Okay, let me go back. Go back a little bit.
Of that,
There we
how long
go.
that took.
I'd say another 10 minutes or so.
And as far as the time that the troopers went into the house, at some point the troopers obviously came out of
Okay,
the
yeah,
house,
all I
correct?
need is 15 more
How long it
minutes.
was that they were inside the house?
More than 30 minutes, less than an hour.
Now, at any point in time while we were there, did you yourself or did you see anyone else touching or making any contact? Or
These questions are like super random. Why are you asking these random questions? It's weird.
As I was walking out, I saw my Uncle Brian and my Aunt Nicole.
And you were going out, and what were they?
They were coming in.
And in addition to your Uncle Brian and your Aunt Nicole, was there anybody else that you recall that was with them when they came into the house?
No, not that I remember.
And what, if any, exchange did you have with your uncle and your aunt as you were going out and they were coming?
I just said, I'm going home. My mom wants me home. I love you guys. Bye.
So when I first walked in, I actually had seen my cousin Colin. He was standing in the foyer area. And I remember I said to him, like, oh, hi, what are you doing?
And Mr. Albert, just one last question. When it came to your arrival at 34 Fairview Road on the evening of, or the early morning of January 29th, when you leave, beyond your Uncle Brian and your Aunt Nicole, did you see anybody else older than yourself or anybody else related to that group coming to the house that, you know?
You can't just hide behind the idea, if you're a Hank Brennan, or even an Adam Lally, or a Laura McLaughlin, by the way, and say, well, I'm just doing the job. No, you're not doing the job. You're affecting a life. You're affecting many lives. You're affecting many, many lives. Look behind you in the view that you've got behind you right now. Those are the lives that you're affecting. Knock it off. Stop being a little whip and acting like this is just a job and no big deal. I'm just going to go on to my next job. If that's the case, God help us in the judicial system. God help us.
Exactly.
You have a broader responsibility, not just in
Talk
your job,
about
to
it,
do
AJ.
the right goddamn thing.
This is my opinion. I think that the state, hiring him as a special prosecutor was not needed.
No.
The state has many DAs and ADAs that they have a case, and they brought Mr. Brennan in as a defense attorney. He's not a prosecutor.
Yeah, why was Brennan hired exactly?
What did Adam and Laura say to you guys afterwards? Like, what, looking ahead?
Yeah, I mean, they were disappointed in the outcome, but Adam said, he goes, we're just gonna do it again. He's on start tomorrow. So they're confident. They have the truth on their side. Unfortunately, if you pay high-powered attorneys enough and put enough lies out there, you start influencing people to the point where there's just no turning back.
I had paused it. Notice the part he said influencing people. I think the main reason they got Brendan, in my opinion, it wasn't for Karen Reed. It was to get Turtle Boy. That's my opinion. Take it or leave it. Hank Brennan was not hired to get Karen Reed convicted. He was there to go after Turtle Boy, which they did try to do, but Turtle Boy, from far as I know, basically won that case.
I think people just don't want to admit that they were wrong or duped. But they're confident, and we're going to go at it again.
And if there was a larger, more interested media out there, they would be asking Michael Morrissey these questions. Is he still handling murder cases? And if so, what are you going to do about this? And you saw this type of testimony and how there's no policy. There's obviously a culture of non-disclosure in that office. There's clearly negligent supervision going on in that office, even at the highest levels.
The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold.
Did you note whether or not her medical examiner, Dr. Stringfellow, mentioned hypothermia as a potential cause of death in this case?
She did put that on the death certificate,
Along with something else?
along with the blunt force head injury.
Do you agree with or concur with the blunt force head injury? as a
Yes,
cause of death?
yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment. So those are the two things you have to look at. And this was from a person who died to exposure to a cold environment. And this is the stomach has been opened, and we're looking at the inside of the stomach. And the normal appearance is kind of pinky white, that's how it should look like. And what's abnormal here is all these black dots, which are the Wisniewski's ulcers, which are diagnostic of death due to exposure to the cold. And this is the Mr. O'Keefe's stomach, which has been opened up, and we're looking at the inside. We see that the mucosa is a little bit red, and there's a little bit
Be
of
back in a second.
increased blood flow here. And this is the normal pattern of the inside of the stomach. It's kind of ridged. That's called rugae. That's the normal folds inside the stomach. But there's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
We're not a result of a fight.
You were asked questions about a nose laceration.
Yes.
And you offered that was not consistent with falling backwards on the head alone.
Correct.
You were asked if that was consistent with a punch. Did you provide an opinion that it could be consistent with a punch?
I did provide that.
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack.
Do you have an opinion as to whether or not the wounds that you see, the pattern injury that you see on Mr. O'Keefe's right arm, is consistent with an animal bite or claws?
Yes, it is, very much.
Those injuries on John O'Keefe's arm are from a dog, period, full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud
look at the
on the jury.
tells
The
it
general
all.
ruling that Dr.
What are we
Lafasado
talking
could
about?
only suggest O'Keefe's arm injuries were from an animal, but not from a dog specifically, resulting in several sidebars throughout the morning and parts of the doctor's testimony being struck from the record.
A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence.
Except it's not true, is it?
I did not hear her ask that. I was told she was asked that. In
The answer to my question, Ms. Roberts, not your question. What you told grand jurors is not true. I never heard her ask anyone to do anything.
I did not.
Why should the witnesses who have committed no crime be fully blessed by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the candid community and everyone who feels invested in this case to hear all the actual evidence at trial before signing guilt of people who have done nothing wrong. And certainly before taking it upon yourselves to harass citizens who evidence shows have done nothing in this matter but come forward and be a witness.
It has been suggested, but never proved, that O'Keefe may have been killed inside this house owned by Brian and Nicole Albert and mauled by their dog Chloe. The Alberts say they only found out about John's death when Jen McCabe, who is Nicole's sister, barged into their bedroom.
I walked over to the bed and I was like, Brian, Nicole, Brian, Nicole. He was upset and I immediately thought something had happened to one of her children or one of my children, because why else is she in my bedroom at 6:30 in the morning right now?
The idea that multiple police department, EMTs, fire personnel, the medical team, and prosecuting agencies are joined in on taking over a gas conspiracy to be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
You do realize for this conspiracy to be true, it would take 30 to 50 people. You'd have to have multiple cops on 2 different police departments, multiple civilians, the medical examiner, firemen, EMTs, you name it. That's how preposterous and silly this is. And great question. I don't understand how people talk.
In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so.
Put all the powers that be want answers ASAP, correct?
Yes.
You knew, Trooper Proctor, that there was brass that wanted this case wrapped up quickly and efficiently.
Is that right?
Objection.
I'll allow that. Is that what you were thinking?
No, the people want an answer, sir.
And you were texting this to your high school friends, again, 16 hours into this investigation, right?
Correct.
And you knew at that time You knew at that time, Trooper Proctor, that this was not going to implicate in any way, shape, form, or fashion another cop, correct?
Correct.
And then you wrote what?
Intentional or not?
Intentional or not. Is that right?
Yes.
Your words.
Correct.
0095 then chimes in, gotcha. He was frozen in the driveway and she didn't see him? Question mark. Correct?
Correct.
And you wrote what?
That's another animal we won't be able to prove.
That's another animal we won't be able to prove. Correct?
Correct.
Trooper Proctor, you knew that there were going to be things in this case, even 16 hours into this, that you just admitted you would have zero proof of. Correct?
Objection.
Sustained, you can ask it differently.
Did you mean by that statement that this was one of several things that you knew we would not be able to prove?
That statement, that's another animal we won't be able to prove, references the intentional or not part.
You didn't care at that point when you wrote that, you didn't care what you could or could not prove, did you?
Objection.
I'll allow it.
Is that what you meant?
No.
You had a narrative that you had developed, and you would pursue it no matter what the proof was. That's what you meant by that statement, correct?
Objection.
Did you mean by that statement that you were going to pursue this case no matter what the proof might be?
What I meant by that statement was if Miss Reed backed into Mr. O'Keefe intentionally or not.
Who's the retarded client?
I'm referring to Miss Reed, again, unprofessional language.
I'm asking who you were referring to.
Miss Reed.
You've got an explanation. Who was it you were referring to as retarded?
Miss Reed.
Karen Reed, the woman sitting to my left.
Yes, sir.
Subject of your investigation as a professional, correct?
Yes, sir.
As a qualified, objective investigator, the person that you were investigating, you referred to your bosses as retarded, correct?
Again, poor language on my part.
Poor language is one way to put it. Completely offensive is another way to put it, right?
Objection.
I gotta sustain that, Mr. Jackson.
What did you tell your colleagues that you were looking for as you sat at almost 10 p.m. at night on a Wednesday night, August 17th, 2022, looking through Karen Reed's phone?
I didn't tell them I was looking to do anything. They knew I was going through Miss Reed's phone. I provided a inappropriate joke as an update. They knew I was going through location data, text messages, Google searches. But like I mentioned earlier, I had to stop.
Except Trooper Proctor, none of that really professional sounding stuff ended up in your comments to your bosses.
Again, it was a poor joke.
Yes or no?
Did not know.
It did not.
No,
As a
sir.
matter of fact, what did you write after you talked about
We
your,
should be about done.
quote, retarded client's phone?
Objection.
I'll allow it.
No news so far.
No news so far, correct?
Correct.
So you said that to your bosses.
Yes, sir. I believe poor jokes have, in unprofessional language, have no bearing on the integrity, the facts, and physical evidence of this case. Yes, sir. It's a private text thread with high school friends. A private text thread with high school friends.
Proctor was fired in March by the State Police Board for the mishandling of evidence and inappropriate behavior during the Karen Reed investigation.
And this includes 9 participants, 9 chat participants that you engaged with?
That's correct.
Trooper Proctor, you never thought when you were engaged with these other individuals that this particular set of chats would ever become public, did you?
No, I did not.
But a larger Proctor issue remains. Skip-Issue and other defense attorneys rushed to court last week to prevent the scheduled destruction of Proctor's cloud data obtained by the FBI during the Reed case. Data they say could impact dozens of criminal cases he was tied to.
Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict.
Also, on cross-examination this morning, Colin Albert told the jury that he has known the lead state police investigator in this case, Trooper Michael Proctor, since he was a child.
And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie.
He said he does know the Albert family, who owned the home where O'Keefe was found, but only through his sister and not well.
I'd classify it as acquaintances.
This should be seen for what it is, and not used as a pretext to attack and harass others. What's happening to the witnesses, some with no actual involvement in the case, is wrong.
By adopting their, quote, note of concern and then declaring Colin Albert did not commit murder. This was one of the federal letters to DA Michael Morrissey and written dated March 21st, 2025.
It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now. I am releasing this court statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court.
So you'll remember the credible claims that the Albert family, Julie
Okay, we're done
Albert,
here.
actually had a hand in writing
Please
this
like,
statement
share,
of Mr.
subscribe. See y'all
Morrissey.
later.
You
Peace.
can't make this garbage up if you try.
God save the Commonwealth of